In 1913, Mr. Smith, the owner of a plot of land on Hastings Street, went to the British Columbia Court of Appeal to ask them to reverse a trial judge's decision to award $179 in damages to his neighbor. A decaying cedar tree had fallen from Smith's lot onto Reed's yard during a windy storm, causing damage. Smith did not agree with the ruling, so he appealed to the higher court. In 1971, a man named Harold was caught making loud noises on Granville Street as part of his religious ceremony. He found himself in the BC Court of Appeal. The Crown appealed the ruling from a lower court, which said that the bylaws of the City of Vancouver disallowing loud noises did not apply to religious groups.
Are the ravages of age on your hair making you look and feel older?
In 1986, a man underwent surgery to treat baldness. In 1993, he found himself watching a telecast of his baldness treatment. He sued the broadcaster on the basis that the broadcaster had intruded on his privacy. The trial judge awarded him what he considered a paltry sum of money, so he approached the BC Court of Appeal.
In a perfect world, courts would be irrelevant. Everybody would get along. If they had a difference, they would resolve it amicably. We know that in the real world, that doesn't happen, and there are disputes and conflicts.
One I heard recently involved a young mother who was crossing an intersection very near the courthouse. Was struck by a truck and, of course, injured, and the question was whether she was responsible because she crossed at a red light or whether there was any responsibility on the part of the driver.
The purpose of the court is to be a place where people engaged in a dispute can come and know that they will get an impartial decision on whatever it is that is dividing them.
For that person, it can be the most important decision in their lives. And that haunts. That haunts me.
There are no stirring speeches made in the Court of Appeal. Underneath the argument, there are moving considerations of humanity that everyone is profoundly aware of. It's a form of theatre in which the emotions are present but are distinctly subdued.
The essence of the rule of law is this. It means we live in a country where you can depend on the law. You can depend on your rights being determined according to law. The only people who can interpret the rules are the courts. Everybody's got to live by those rules. That's what civilization means.
People tend to talk about the famous cases, but the reality is that most of the work the court does is the ordinary. But even in those ordinary cases, there's moments of real human drama.
The appeals process really doesn't make it into that public imagination. It's really quite academic in a lot of ways. An appeal involves 3 judges. An appeal never has a jury. Appeal courts don't hear live witnesses. They don't hear testimony in that way that's so commonly depicted.
In every man's life, there are pinpoints of time that govern his destiny.
We look at a record created in the court below, and the record includes a transcript of the evidence that was presented. It would include all of the documents that the court below looked at. We would hear legal arguments from the lawyers representing the interested parties. What we're usually looking for is an error of some sort.
Has there been a miscarriage of justice in the trial court? Did the trial judge make an error in law? Was there a misapprehension of the evidence? Is the decision a fair one?
For the province of British Columbia, the Court of Appeal is almost always the final court. We hear appeals from the Provincial Court, from the Supreme Court of British Columbia, and in about 95% of all of the cases that the Court of Appeal hears, that's the last word.
The filtering of cases going from provincial courts of appeal to the Supreme Court of Canada is a very difficult task that the Supreme Court of Canada has to perform, and I would imagine that the ratio of cases in which the Supreme Court of Canada grants leave would be not more than 1 in 10. They have only so much time, and they have to try and find the cases that are of greatest national importance. The Court of Appeal will consider the legal consequences of the finding of fact. They'll do so on a much more careful argument than counsel are able to present at trial. And most important of all, there are 3 minds working together, which may be a much more mature process than a single person is able to bring to the task.
It is comforting in that there is a Court of Appeal, and they can straighten out mistakes that you've made. Even the best judges sometimes make mistakes. It's unavoidable. And it means we do acknowledge our limitations, and sometimes they're pointed out by the Court of Appeal.
I think by the end of the 19th century, there was a movement across the common law world to have separate courts of appeal. And BC was booming in the early 20th century. I think having another court was a sign of progress. As a result, in 1907, the legislature enacted a Court of Appeal statute. It didn't actually appoint judges until 1909, and I think they heard their first case a year later.
In 1910, the BC Court of Appeal heard its first case. Mr. Prasilowski had a cow stolen from his field and accused 3 men of the theft.
Prasilowski was a case involving perjury. Mr. Prasilowski had accused 3 other men of stealing a cow. They were acquitted at their trial, and after their acquittal, charges were brought against Mr. Prasilowski for having perjured himself at their trial. And what the Crown wanted to do was to introduce evidence from other sources about what Mr. Prasilowski had said at the magistrate's hearing. And that was the question that came in front of the Court of Appeal. Could other evidence about Mr. Prasilowski's statements, other than the magistrate's notes, be introduced in court and used in his perjury trial?
Common law is judge-made law. It's law that judges apply when there is no clear precedent and when there is nothing in a statute or a regulation that they're bound to apply.
Statutes were largely the product of the king and his great men, the aristocrats, who ultimately became the House of Lords. Over time, Parliament divides into 2, the House of Lords and the House of Commons. And eventually, the formula for a statute is a law passed by the Commons, the Lords, and approved by the King. All 3 have to act together to pass a statute.
The principle is parliamentary supremacy, and if it comes down to a head-to-head battle between a piece of legislation and a court decision, the statute prevails. But both common law and a statute have to conform to the Constitution, and if a statute is contrary to the Constitution, then the statute falls.
British Columbia has been historically and into the present day distinctive within Canada for several reasons. It's had a different population base. It's had the largest proportion of people from Asia, a lack of an agricultural base like the rest of Canada, but has had to be dependent on various natural resources, which have changed over time.
In the colony of British Columbia, the first judge was Matthew Bailey Begbie. He was appointed as a judge in 1858. He was only 39 years old at that time. He was the judge in this colony. If you didn't like one of his decisions, in theory you had an appeal to the Privy Council in England. In reality, there was basically no appeal. You can imagine in 1858 the difficulty of getting from British Columbia to London on an appeal. Judge Begbie would get on horse or go by foot, and he would go to any place that court needed to be held. He would use barns, he would use whatever building might be available, or he would stand outside, or he would sit on his horse outside and hear cases and give his decisions. The law is constantly shifting because circumstances change. The way people interact with one another changes, and the things that we can interact about change over time.
The court operates in the context of the society of the time. The fever of the hour, the demands of strident interest groups, and the policy of the government of the day ought not to influence a court. The felt needs of the time should, and a judge must know the difference.
Like any living body, this court is a creature of its time. Laws are, after all, human constructs carefully designed by human beings, evolving over time, prescient, inspired, and sometimes flawed.
In 1914, a shipload of Indians set sail from India in order to come to Canada. They did so by way of Hong Kong and Yokohama. There were approximately 375 people on the ship. And the reason the Komagata Maru incident has become so controversial is because the people who were British subjects and members of the British Empire were refused the right to land in Vancouver.
In the early hours of Saturday, May 23, 1914, the Komagata Maru anchored in the Burrard Inlet. The passengers were dressed, bags packed, ready to go ashore. A launch boat came to meet the ship. On it were customs officials, a medical doctor, and immigration inspectors Hopkinson and Reed. The passengers were not allowed to land. An immigration launch boat with armed guards patrolled the ship day and night. The passengers were deprived of food and water in an attempt to send them back. By June 10th, many had become sick, and one passenger had died.
At one point in this incident, in 1914, a test case was taken to the courts to see whether or not the decision of an immigration board of inquiry to exclude one of the people on this ship, whose name was Munshi Singh, could be somehow overturned in the court, because that would have been a significant legal victory.
The face of Munshi Singh is lost to time. What is known is that the Immigration Board of Inquiry denied his application because of 3 recently enacted orders in council. One of those grounds was the continuous journey regulation, which stated that to be admitted into Canada, immigrants had to come by continuous journey from their country of birth. Munshi Singh had started his journey from Hong Kong, which, although a British dominion, was not his country of birth. He also did not have the requisite sum of money. On June 24, 1914, the BC Supreme Court handed down a judgment that, under the new orders in council, it had no authority to interfere with the decisions of the Department of Immigration and Colonization.
The Court of Appeal sat a court composed of 5 justices of appeal. All 5 dismissed Munshi Singh's case. And one of the judges, only one of the 5, made remarks that were certainly consistent with the racial attitudes of probably most Canadians at the time.
Those who become immigrants are, without disparagement to them, undesirables in Canada, where a very different civilization exists. The laws of this country are unsuited to them, and their ways and ideas may well be a menace to the well-being of the Canadian people.
It's interesting that the other 4 judges did not. And, one can never know what their views were. But those judges made it clear that it was not any part of their job to comment on the policy of an act passed by Parliament. And, of course, in those days it wasn't. And so it was inconsistent, one would think, for a judge to make a comment on the policy of the act, which Justice McPhillips did. The lawyers for Munshi Singh had a real uphill battle, because in those days there was no Charter of Rights and Freedoms. The only attack that they could make on the law was one that was probably doomed to fail. And the Act itself said that decisions of these boards of inquiry really could not be reviewed by a court.
There's no doubt that the Court of Appeal had very limited powers to overrule the Board of Inquiry. Having said that, I don't think we can let the Court of Appeal off that easily, because the members of the Court of Appeal no doubt were products of the environment at that time, and they no doubt harbored the same beliefs and attitudes and sentiments as the population at large.
Section 23 of the Immigration Act is a very sweeping and unusual enactment, going direct to the question of our jurisdiction.
People in the Anglo-Saxon world generally saw the Anglo-Saxon race and civilization as sort of the culmination, of thousands of years of human development.
And it was genuinely believed at that point in time by people who were conveniently white, that these other groups were not capable of integrating into Canadian society.
The apologies were formally made in 2008, and it took a long time for both levels of government to apologize.
I think the law is always in search of justice. And it can't all be done at once. Nobody is that wise. No court is that gifted. So you work it out piece by piece, and it takes a long time. But what you built in the end, I think, is a sounder piece of work. Incremental approach is necessarily the approach that the law takes, and I think it's far better than asking judges to work out the whole future of a people or a legal conception all at once. God forgive me, they're not capable of it. We're not capable of it.
Regrettably, there was no happy ending. When the ship was turned back amid a storm of controversy and animosity and hatred, the ship returned to India. There was no great welcoming party on behalf of the government. In fact, the British government, which was governing India at the time, punished those people who were involved in the so-called rebellion. Many were imprisoned, some were killed, others returned to their villages. Their lot in life was not a happy lot in life.
The story of the Komagata Maru went on to become the stuff of legends. But there are other cases that have also been a product of their time and place, cases that never made it onto the front page of any newspaper. The late 60s and early 70s were fiery times. The Royal Commission on the Status of Women in Canada was instituted by Prime Minister Lester Pearson in 1967. In 1974, the RCMP decided to allow female members for the first time.
Rivera was an interesting decision of the British Columbia Court of Appeal back in 1974. And it was a decision that related to a jury trial involving two charges, one of breaking and entering and one of rape. There were two versions of what happened. The woman concerned said that the accused had broken into her house at night and raped her. And his version was that he had known her and had come along and found the door unlocked and come in, and eventually they'd have consensual sex. The jury came to an interesting decision because it convicted him of breaking and entering and acquitted him of rape. Both sides complained that the judge had made errors in the trial. The court decided that both those complaints were justified and sent the case back for a new trial.
But it is in the fine print of that decision that other prevalent attitudes of the era emerge. In discussing the possible ways the jury may have come to their verdict, Justice Robertson noted that, as the law stood at that time, the requirements for proving rape were stricter than for proving breaking and entering.
The jury may well have come to the
conclusion that the accused entered the suite through the window with the intent of raping the complainant, but that she, having a healthy liking for sex, lost her fear of him under the influence of his reasonably gentle caresses, and was a consenting party to the intercourse that followed.
It was the jury that had to decide on what actually happened that night, and the Court of Appeal would have been concerned not to replace the jury's decision with its own. But nevertheless, this statement was made that it was not a fantastic idea to think that a woman would consent to have sex with a man who'd just broken into her house. Juries were told that it was unsafe to convict on a woman's word alone. That's no longer the law, but Rivera very much reflects the law of the times, in that women started in a sort of deficit position in terms of their credibility. People who testified that they'd been raped could be asked many questions about their sexual history. The concern was that people could reason, oh, she was a loose woman, so she wasn't really raped. And so Parliament again acted to address that concern shortly after Rivera in 1976 to put significant limits on what questions could be asked. And in the early 80s, not all that long after Rivera, the law was completely revamped to replace the law of rape with what we now call the law of sexual assault.
At one time, the judiciary was the private preserve of white males.
Most of them were Scots. They virtually all came from one religious tradition.
Men made all the decisions. It was men who were elected to Parliament. It was men who were in the executive of government. That, thankfully, has changed. Because if any institution is going to have the confidence of the public, that institution must in some general way reflect the population makeup.
People don't get appointed to the court until they've been in the practice of law for practical purposes at least 15 years. That alone would mean that the courts will never be reflective of the precise makeup of the province as a whole. And those judges will sit on the court for 20, 25 years. So, of course, it's always going to be behind the times in the sense of comparison with the makeup of the population of the province at a given time.
I think justice means fairness, but our conceptions of fairness change. Our ideas of what is fair and reasonable change.
Probably the most important change that's happened in the court's composition in the last 20 years has been the addition of women. And in our court, we have 22 members, 10 of whom are women. It's, if not the highest, one of the highest proportions of women of any court in Canada.
There have been many changes wrought in family law, in criminal law, human rights, and discrimination and equality that have been highly influenced because there have been women on the court who see those issues in different ways from their male colleagues.
Despite changing notions of what constitutes justice, there remains one cornerstone of the court that judges and lawyers guard fiercely. That cornerstone is the independence of the judiciary.
In any kind of a competition or a dispute, you want to have a referee or a judge or an arbiter who is impartial or unbiased and who is seen to be impartial.
Well, it means that judges will not be subject to instructions from those who exercise authority in government or from any other source whatsoever. That they do not allow their own personal opinions, their own personal beliefs, their own preconceptions to guide them, but rather that they hear the arguments that are made before them with an open mind.
April 26, 1942. Adolf Hitler became the supreme judge of Germany. All judges henceforth were to judge like the Führer. Marcus Luftges had been sentenced by a judge to 2.5 years imprisonment for hoarding eggs. Hitler wanted the sentence changed, so Luftges was executed for his crime. In 1948, 16 judges, including the judge who had condemned Luftges to death on Hitler's instructions, faced a war crimes tribunal at Nuremberg.
An independent judiciary is the hallmark of a free society, and you will not find an independent judiciary in any autocracy. No dictatorship would dare to give that freedom to judges, because it would result in the downfall of any autocracy if you could have judges that were applying the law according to principles of justice in individual cases.
They are independent of government. In fact, the independence goes so far as that I am not entitled in any way to telephone a judge or to contact a judge to give my views as to how a particular case ought to be decided, even though I am an elected representative of the public.
In favor of the amendment will please say yay.
Some people think that we still live in a time of parliamentary supremacy, where Parliament can do anything it wants, and nobody can do anything about that without throwing that government out and electing a new government.
John Diefenbaker, the Prime Minister in the late 1950s, early 1960s, had always wanted Canada to have something like the American Bill of Rights. He couldn't get provincial agreement, but he did manage to pass a federal statute called the Canadian Bill of Rights.
Not so much an ending, but a fresh beginning. Let us celebrate the renewal and patriation of our Constitution.
Through the 60s and the 70s, more and more people thought that it would be a good idea if Canada had a real Bill of Rights that was part of the Constitution. That's the movement that really came to fruition in 1982, when in the new Constitution Act we got the Canadian Charter of Rights and Freedoms.
The Charter didn't create those rights. The rights existed. The UN Charter predated our Charter by a long time, and people have long recognized that everybody is entitled to fundamental human rights.
One of the most important reasons for having a Charter of Rights and Freedoms is to protect the rights of minorities. And that's particularly the case when you're dealing with the equality rights section of the Charter. Minorities, almost by definition, don't have the same clout that majority groups do to use the political process. There's a phrase, the tyranny of the majority.
It was an entirely new function for us in Canada. It is carried out under the law that has been laid down by the elected representatives of the people and can be changed by them at any time. The Charter can always be amended by the elected representatives of the people in Parliament and in 7 legislatures. It's not a very difficult task. The Charter contains an override clause which permits Parliament or an individual legislature to override most of these rights and freedoms, so that the court cannot review the law that they've passed to see if it conforms with these rights and freedoms. But that power has very, very rarely been exercised.
Whether seeking religious freedoms or natural resource rights, minority groups have always taken their struggles to the courts, trusting implicitly in their promise of impartiality and independence.
Mears Island is this pristine jewel of an island off of the west coast of Vancouver Island. On November 21st, 1984, there was a vessel that left Tofino. It had 17 employees of McMillan Bloedel on it with their chainsaws, and they were on their way to log clear-cut parts of Mears Island.
Well, this island won't be destroyed now.
You're right, it won't be.
At stake was Tree Farm License 44, held by McMillan Bloedel, which gave the corporation rights of logging on the island.
They had a discussion, and the McMillan Bloedel loggers were told by the chiefs and the others assembled there that they were more than welcome to come ashore. They were more than welcome to enter onto Mears Island, but they had to leave their chainsaws behind. This wasn't acceptable to Macmillan Bloedel, and off they went to court to get an injunction to clear the way so they could begin their logging operations on Mears Island.
The Mears Island case challenges the identity of British Columbia on several levels. Certainly, forestry and lumbering are critical to the history of British Columbia, and they're critical to a sense of who British Columbia is. But then you also, on the other hand, have a growing environmental movement, because in British Columbia you've had, since the 1960s, and certainly since the beginning of the century, a very strong sort of counter-group who believe that this is a particularly precious place in terms of its physical setting in the environment, and these need to be protected in various ways. And then you've also got a growing sensitivity to First Nations and to First Nations needs and First Nations demands, and trying to be more respectful of them as well.
One of my chiefs has said that we have learned the white man's laws, and we're going to use it.
We were taking on the establishment. There's no doubt about it. For a small law firm to take on a case like this that we ran right up into the Supreme Court of Canada was quite an honor, but quite an ambitious and difficult task. The Chambers judge, Mr. Justice Gibbs, said that Aboriginal title did not exist in British Columbia. And he said for that reason, there was no serious issue to be tried. The First Nations showed admirable restraint. They didn't go out and show contempt for Mr. Justice Gibbs' decision. In a very orderly way, they instructed me and lawyers to go forward in the Court of Appeal, challenge that finding, say Mr. Justice Gibbs erred in law. There is such a thing as Aboriginal title in British Columbia.
That was an accident of history. BC was about the last place the Europeans colonized in North America, and by the time the Europeans came here, our industrial civilization was so advanced that we didn't need the Aboriginal people. We didn't need them as guides. We didn't need to trade fur with them. So we didn't make treaties because BC's founding fathers said we don't have to. Why should we bother with these people?
The Mears Island case was the first case in which the Aboriginal title claim gave rise to injunctive relief to stop industrial development until the trial could be heard. The arguments being made in the Court of Appeal were that you have to support the lower court judge, the judge who refused the injunction to the First Nations, because if you grant that injunction, there'll be a rash of applications all over the province, and society as we know it in British Columbia will come to a halt. Development will stop. The very economic base of the province will be put in question. And the majority of the justices in the Court of Appeal didn't accept that argument.
It was both politically on the ground and legally in the courts a fairly explosive issue. The court basically said that the Aboriginal title question had been postponed and avoided for generations, and it was really now time to say to both sides, this has to be resolved. And if it takes issuing an injunction to stop logging on one island to do that, we are 3-2 prepared to do it.
In describing Mears Island's importance to the Indians, Mr. Justice Seaton said, the Indians wish to retain their culture on Mears Island as well as in urban museums.
Contentious as it was, a public opinion in the Vancouver Sun of that year showed that 75% of those who had any opinion on the matter supported the court's decision.
In the Mears Island case, the Court of Appeal did not say that Aboriginal title does exist in British Columbia. All they said was, we're not prepared, like so many other courts and judges before us, to say that industrialization can go on in the face of Aboriginal title claims, and we'll ignore it until it's been proved at a later date. The trees are still there and standing because the First Nations went to trial, proved their Aboriginal rights and title to a point where it was recognized by the provincial government and perhaps others that we might win at trial. Negotiations began, but everybody agreed that the trees would not be cut without the First Nations' consent or until the trial was later concluded.
It took a while for the provincial government to come on board, but they did in the 90s. And that's why we have the whole treaty-making process. And the idea is to recognize that it isn't just the forest companies, the mining companies who own the resources of this province. The Aboriginal people owned them before we came, and they still have an Aboriginal interest, an Aboriginal title that has to be dealt with.
From Aboriginal rights, women's rights, to gay rights, the BC Court of Appeal found itself at the epicenter of the social movements of the century. The court had been asked to intervene in cases where families argued over property, spouses fought for custody of their children, and communities battled each other for access to shared resources. In 2003, they heard the case of Egal versus the Attorney General of Canada. At stake was the very definition of marriage. 8 gay and lesbian couples in BC had applied to the British Columbia Director of Vital Statistics for a marriage license.
Went into the office and said, could we have a marriage license application? And yes, and we couldn't decide who was going to be the bride, so Murray crossed out bride and put groom, so we're both grooms, and we took it to the lady at the desk, and she looked at it and she says, "This is for you two." I wondered when we were going to get one of these. So she said, "I'm going to have to make some phone calls." So that's when it really started, and she said, "I'm sorry, I'm being instructed that I can't issue with a license."
In the previous 10 years, the gay and lesbian community had made a number of important strides in having the courts recognize them as equal citizens in this country. They were afforded equal benefits to the law, such as old age pensions and the like. But marriage was the ultimate prize. 10 years before we argued the same-sex marriage case, the courts probably wouldn't have been ready for it. Neither was the public.
Case that was relied upon by our opponents was a case called Hyde and Hyde, which was decided in 1866 in England. And the line that gets quoted over and over again is this: "I conceive that marriage as understood in Christendom may for this purpose be defined as the voluntary union for life of one man and one woman to the exclusion of all others." Our opponents said, see, that means that marriage, in its essential nature, it is a heterosexual institution.
Our desire is, as our society has recognized in the past, to encourage heterosexual marriage and to make it stronger and better. We don't believe that changing the definition of marriage is going to do that.
The BC case was not alone. Similar cases were being heard in Ontario and Quebec. On October 13, 2000, the case went to the Supreme Court of British Columbia, which produced the first judgment on same-sex marriage in Canada.
It was a shock beyond anything I can describe to you to hear a judge say, marriage is marriage is marriage.
The presiding judge ruled that judges could only change the common law in incremental steps. He further ruled that the equality rights that were being infringed upon in this case met the crucial test in Section 1 of the Charter, which allows for limiting rights if they are considered reasonable and justified in a democratic society.
I couldn't believe that a judge would say, "You're being discriminated against, but we're going to allow it anyway. And we're going to leave it up to the elected government of this country to decide whether or not you have your rights."
Having lost the battle in the provincial Supreme Court, the gay and lesbian couples decided to approach the BC Court of Appeal. A 3-member panel of judges, Madam Justice Prowse, Mr. Justice Mackenzie, and Mr. Justice Lowe, listened to their appeal.
Our main objective was to persuade the Court of Appeal that the concept of marriage at common law or in the Constitution was not confined to the gender of the people being married. There was a concept that was flexible enough to be interpreted in a manner that was consistent with the fundamental values and mores of our society today, not just in 1867.
The three justices were all in agreement that the Supreme Court judge had erred in his conclusion that the definition of marriage was frozen in 1866.
One of the things I learned a long time ago, contrary to what I thought, was never to tell the court that it's about to embark on a landmark case.
The justices concluded that, despite the common law bar to same-sex marriage, denying gay and lesbian couples the right to marry was denying them their fundamental right to equality.
Many people ascribe a mysterious process to the courts. Many people say courts make decisions based on reason and rationality. But when you get right down to it, our Court of Appeal and the Supreme Court of Canada are a panel of wise people, the wisest we have, who are asked to decide the hard questions. It's not reason that takes you to the right answer in this case. It's justice. And those are not the same.
The Court of Appeal suspended its judgment until July 12, 2004, in order to give the federal government time to review and revise legislation.
Once the Ontario Supreme Court said, okay, these people should have the right to get married, and then the appeal court in British Columbia said, yes, we agree these people should have the right to get married, but they're going to have to wait a year. The people in Ontario who were fighting for same-sex marriage went back to the appeal court in Ontario and said, this is not fair. Why should we have to wait a whole year to get married? Let us get married immediately, which is what the appeal court in Ontario agreed to and said, yes, you can get married tomorrow. And so once Ontario had same-sex marriage from that moment, we went back to the appeal court and said, well, the appeal court in Ontario said everybody can get married right now, then why can't people in British Columbia get married right now? And the appeal court in British Columbia said, do you know what? You're right. Go and get married.
To marriage.
To marriage, yes.
I have watched the Supreme Court of Canada 3 times in my life since becoming a lawyer say no to same-sex rights. And I was finally able to see my courts, our justice system, acknowledge, respect, grant the simple dignity that is what civil rights are about. It was an amazing day.
In 2005, 2 years after the BC Court of Appeal ruling, Parliament passed the Civil Marriage Act, legalizing same-sex marriages across Canada.
Courts make decisions that are, in a sense, black and white. They either decide for or they decide against. And sometimes justice is muddier than, in fact, what the courts can do. And I suspect that this is one of the reasons why the Court of Appeal has historically had an important role in British Columbia. But it also has the opportunity to look at black and white in a different way and maybe come to a different conclusion. So the black is not quite so black. And I think that's one of the critical elements for justice not only being done, but being seen to be done within a society.
In the years between the Munshi Singh case and the same-sex marriage case in the Court of Appeal, a number of things had changed. The most important change was the Charter of Rights and Freedoms. The judges are now assigned the job of saying whether a particular law is consistent with the fundamental law of the land, and they couldn't do that in 1914.
I think temperament is fundamental. A judge has to be balanced and patient and willing to listen, even to arguments that he might not or she might not wish to hear, or that might not appear to have much merit at the outset.
Is it hard to be a judge? The answer is yes, it is. It's an exhausting task. You're dealing with everybody else's problems. Everything that comes before you is a problem that deeply concerns other people. It takes everything you have to offer. It should take everything that you have to offer. And so, of course, it is hard work. A very difficult job.
Judge not, lest ye be judged. God was supposed to make the decisions in the ordeal, not human beings. And when we move to human judgment, that becomes even more acute.
I don't know that any system that is ultimately run by human beings can be completely free of bias.
The law is a quest for justice, and the goal of justice keeps receding beyond the horizon.
You can ask people to define justice. You can ask them, what is justice? And you'll never get a satisfactory answer. Injustice is very easy to identify. Justice is a perfect thing and beyond the ability of humans to describe.
Good. Great. That's very good. Thanks, very good. Here we go, good.
The British Columbia Court of Appeal is now 100 years old. These walls stand as mute witnesses to our shared history, a record of our struggles and the hope for a more equitable future. What kind of cases might the court hear in the future? Those decisions might determine the lives we lead, in big ways and small. In its wisdom and judgment lie the fates of many people. Ordinary people like you and me.
Grade 12 Law at Dave Thompson Secondary School in Vancouver. And for the group, this is Madam Justice Ryan, who sits on the BC Court of Appeal.
Has it ever been difficult for you to do personal and professional law stuff?
It is hard, and you have to be constantly aware of what you're doing. And eventually you realize, well, somebody has to do it. You don't make these decisions quickly. You have a lot of time to think about it. It's not like Judge Judy. You don't just say, okay, you're out. You have to think about it.
How do you ever know if anybody is telling the truth or not?
That's like the age-old question. How do you know that? You never really know for sure. You have to do your best to assess it. That's the hardest part of the job.